Lunch Talk. Today's speaker is an old friend of CITP, Ron Hedges. Ron has been involved for a long time in issues around electronic information in the legal system. He was for many years a magistrate judge and has been involved in many of the activities of the legal profession around figuring out how to do all of this. So we could hardly have a better person here to talk about today's topic, the Supreme Court electronic information and the Fourth Amendment. Welcome back, Ron.
Okay, thank you for having me. Thank you for everybody being here today. As you can see, I'm going to be talking about how the Supreme Court has addressed electronic issues in the area of the Fourth Amendment. There are a lot of things we're not going to be able to talk about today just because of time. One area we were chatting a little before is the whole concept of encryption and how do you deal with encryption in the context of the Fifth Amendment. Can an individual be compelled to disclose a password or whatever, or is that a violation of the Fifth Amendment? There's some cases on that that's developing. We'll also see some case law interesting on, is there a Fifth Amendment right to refuse to give your fingerprint to unlock something? The answer to that generally is no, because that's not a testimonial act when you are providing a fingerprint as opposed to saying or putting in numbers or the like. But that's an area for another day if we can ever talk about it. I want to talk about the Fourth Amendment today and what the Supreme Court has done. This is me. I was a magistrate judge here in New Jersey. I sat in Newark for 21 years. I'm now with a firm called Dentons out of New York City. I chair an advisory board of a Bloomberg BNA publication on electronic information and evidence and the like. And among other things, I'm a co-senior editor of a guide for federal and state judges by an organization known as the Sedona Conference. If you're interested in things electronic and the like, I suggest you take a look at the Sedona website, see what's there, and if nothing else, if you don't want to become a member, you can download anything, any materials for free. You just have to give your names and lives away so they can get back to you on things. And now some resources. Just a couple things. I gave you an article that was in Digital Discovery and Electronic Evidence. That's the publication I'm chair of the advisory board of. I also gave you a couple hundred pages of summaries of case law, and I assume that's available online for everybody if they want it. That takes me through basically last year. And it's not every decision in the world on electronic information, but it's a good sampling of federal and state case law from the United States. And last, there's this article on Riley that came out a year or so ago, again in a Bloomberg publication that I work with, and that's available for you to take a look at if you're interested in seeing it. I want to start with this, not that we need to read the quote, but just an interesting to put everything in context. The Bill of Rights was written in the 1780s. The Bill of Rights obviously, and the founders obviously did not anticipate new technologies. So unless you're an originalist, and we can chat about that later on when we're talking about one of these Supreme Court decisions, we need to essentially take the new technologies and put them into an existing framework we have. And you'll see, maybe imperfectly, but that's being done on the federal level and again at the state level. We're going to look at a couple Supreme Court decisions that talk about that. First one is United States versus Jones. And by the way, if anyone has any questions or whatever, I know I'm supposed to leave 15 minutes at the end. If you want to ask questions or interrupt with comments or whatever, just raise your hand and tell me what's going on. We don't need to wait till the end. This is a pretty interesting decision. This is not the first decision the Supreme Court did on electronic information. The first one actually is called Psidium, Ontario versus Quan. It was decided a few years before that, and that involved whether police officers had a reasonable expectation of privacy in a communications device so that the police department that employed them cannot get access to the contents of the information. Supreme Court talked about that. That's really the civil side, not the criminal side. But that was the first time the Supreme Court looked at electronic information. The next one is Jones. The government was tracking someone for drug dealing. This was down in the D.C. area. Driver was going between the car was going between D.C., Maryland, and Virginia. There had been a warrant, but the warrant expired. And then you wound up having a device that was attached to a vehicle that was tracking the vehicle on a warrantless search. And that went up to the Supreme Court. talked about whether or not there's something to be done about that. Interestingly, the court went 9-0, deciding that there was a problem with what was going on here and sending the matter back. But first we have Justice Scalia. Everyone remembers Justice Scalia, right? He was an originalist. Does everybody know what an originalist is? Anybody not know? Originalist is scholar, philosopher, lawyer, whatever, who thinks you look at the Constitution the way it was written in 1789, and if it doesn't fit, you don't deal with it. It's the easiest way to describe it. The nominee, the current nominee in front of the Senate, supposedly has a reputation for that. We'll see how that happens. The only originalist left on the Supreme Court now is Justice Thomas. So what Justice Scalia does, he looks at what's going on, and he says, well, you know, this is a trespass. The trespass is to the vehicle. And he looks to 1730 case law from England and says, when you attach something to an object and you really interfere with its use and possession, you're affecting a search, you're affecting a seizure. And he said attaching this device to the bottom of a vehicle was the equivalent of that, and therefore it fell within the Fourth Amendment because you were interfering with the possessory right of a vehicle. That's nonsense. Even if you read the decision from the 1730s, it talked about a significant impairment of enjoyment of an object. Sticking a transmitter on the bottom of a vehicle does not interfere with the enjoyment of the vehicle. But Justice Scalia went this way, and he had three of justices go with him. Not surprisingly, Justice Thomas, Justice Kennedy, and the Chief Justice. And this could be an example of, we're going to do it one way or the other. I'm not writing it. We'll go with this because this is a common denominator. Then you had another opinion by Justice Scalia. By Justice Alito. Justice Alito was the United States Attorney here in New Jersey. He was a Third Circuit judge sitting in Newark before he went up to the Supreme Court a while ago. And he looked at it in constitutional terms. And what he talked about was, you know, we can imagine that a little constable is going to be sitting in a vehicle for a month following it, which is kind of what Justice Scalia suggested, or we need to start thinking about where we are today with technology. And his answer basically was, well, there's a search, something's wrong here, but really this is something for Congress to take a look at, and we should avoid doing anything we need to do more than necessary to address the matter before us. So that's a concurring opinion. The best we can do is apply it and see what happens. And then we have Justice Sotomayor. Justice Sotomayor, her concurring opinion says, you know, we really need to look at something called the third-party doctrine. And we're going to look at a couple decisions later on that apply the third-party doctrine, but we might as well explain it now. There's a Supreme Court decision from 1979. And essentially what it talked about was someone goes to a bank, whatever, gives information. And if the information is given to a third person, here the bank, is there a waiver or maybe not even an existence of a constitutional right? Because you don't have an expectation of privacy you give to someone else. So if I were to give something to one of you with my name, passwords, this or that or everything, if I handed it to you for a reason, whatever expectation of privacy I had in that disappeared when I gave it to someone else. And Justice Sotomayor said, well, you know, we need to revisit this because all these decisions, Smith versus Maryland came out in 1979. We need to think about whether the third-party doctrine really can work when the amount of information we have conveyed back in time, conveyed to all third parties. Are we really intending people not to have an expectation of privacy? I also should tell you while we're talking about the Fourth Amendment, the Fourth Amendment is based on a reasonable expectation of privacy. It has two sides to it. Number one, there's got to be a subjective expectation. So if you pick up the phone and you call someone, you might be able to expect that anything you say is going to be kept confidential. But there's an objective expectation of privacy, and that's something that society is willing to accept is the easiest way to describe it. We had a case kind of like that in New Jersey a few years ago called Stengart. It was not about criminal law. It was about an employee who was having a dispute with her employer. She communicated with her attorney over the employment system, over the employer's system to get out on the internet to get to her own account. the terms and conditions of her usage of the internet, of the computer system, arguably gave the employer the right to monitor what she was saying. Now that went up to the Supreme Court and said, no, it was ambiguous. We construe ambiguities against the drafter, therefore Ms. Stengard has a reasonable expectation of privacy. But what we're looking at there is objectively, other than what she thought, what are the circumstances surrounding the communication or the like that society would recognize? And we can talk about that a little later on, if anyone wants to. So Jones was the first decision. Basically what it does is say, there's something wrong, sends back down, that's about it. And then we come to Riley. How many people have ever heard of Riley? Anybody who listens to read about Supreme Court decisions, you know about it? What's it about? Yeah, what's Riley about? I don't know. Tell me. It was a phone. Whether it was smart or not, I don't know, but it had a lot of stuff on it, right? This is something based on a doctrine that the Supreme Court generated called the search incident to arrest doctrine. Basically what it says is, if I'm walking down the street, I commit some type of a criminal act, and I'm arrested, the police have a right to check me and my immediate surroundings for weapons or for evidence that might be destroyed. That's the concept of search incident to arrest. Riley had that situation. There are actually a couple cases that came up with Riley. Riley was stopped in California in a car. At the time of the arrest, the officer took the cell phone and started flipping through the content. And the question was, is that justified by search incident to arrest? And you look at the decision written by Chief Justice Roberts, the answer is no. You don't have a weapon inside a cell phone. And there's no loss or risk of destruction of evidence, although it's interesting because there are a lot of phones now that have wiping capabilities into them, either remote wiping or doing it yourself. The solution Chief Justice Roberts articulated is, well, police officers should have Faraday bags. So everybody knows what a Faraday bag is? Okay. So the answer is, we don't have to worry about destruction of evidence. Police have a way to avoid that. That's Riley. And whenever you talk about case law in this area anymore in the Fourth Amendment, you have to stop and think about what Riley is about. Now, the article that you have that I gave you was written shortly after Riley was decided, maybe a year or so, and it suggests that there's going to be an expansion of Fourth Amendment jurisprudence based on Riley beyond the facts of Riley. I can tell you, and we'll look at a couple decisions later on, the federal side, the answer to that is no. On the federal side, everyone says Riley is about search incident to arrest. There was no intent to expand Fourth Amendment law and go from there. Something I don't have in the slides that I want to talk to you about is a great little decision that came out of the Wisconsin Supreme Court after Riley. And basically, this is about real-time tracking. It's called State versus Sub Diaz Osorio. Someone kills his brother. He takes the murder weapon. At least the police believe he takes the murder weapon. He takes a car. He's here illegally, and the police believe, number one, he's got evidence with him, and number two, he's fleeing to Mexico. So without a warrant, they go to his cell phone provider, and they track him real time, and he's arrested in Arkansas or some state between Wisconsin and Mexico. His argument is, look, you can't use anything against me. This is a violation of Riley. And it's interesting because the Wisconsin Supreme Court had 5 or 6 opinions come out. One of the opinions say, well, you know, there's also another exception. It's called the emergency exception or exigent circumstances exception. If there's some reason why you don't have time to get a search warrant, police are entitled to search, warrantless, and then you come back and talk about it after. Another decision said, well, you know what? There was a search here, but there's a good faith exception to the warrant requirement. There's another exception. And the police had a reason to believe he was fleeing, all this other stuff going on. And by the way, there was no case law that really said you needed a warrant for this. And so they said, okay, you're out on the good faith exception. There's another argument that said, yes, there was a search. There should have been a warrant. There were no exigent circumstances. But by the way, the evidence against him was so overwhelming, there's something called the harmless error doctrine, which basically means even if you do something wrong, if it would not have made a difference at the end of the day, the state's not penalized for it. And then there's another opinion that comes out and says, well, yeah, this is a Fourth Amendment search. I dissent. There were no exigent circumstances here and the like. They could have secured a warrant, and that's the end of the decision. It's a very split decision. I'd tell you to read it just if you're interested in the area, because it's fascinating the way you see justices are applying Riley after it came in. So when we think about Riley, you got to think about a couple things. Number one, you have to realize it's talking about an exception to the warrant requirement. It does not talk about when you need a warrant. It talks about a warrantless search and what, if anything, the police are allowed to do related to the arrest or a reason for arrest or use of information, getting information without a search warrant. There's a lot of hype to it, but at the end of the day, this is where we stand on that. And then there's two other Supreme Court decisions that came out. Most people don't know about these. This is Grady versus North Carolina. Grady's convicted of a crime. He's got to wear a GPS monitoring device. Can he do that? Any ideas? Can the state require him to wear a monitoring device? We're talking about the Fourth Amendment, so we have to ask the first question is, does the Fourth Amendment apply? Does the Fourth Amendment apply to someone who is wearing a tracking device? Any ideas? Yes, sir.
Well, on face, that sounds kind of ridiculous because the Fourth Amendment is, I think it's widely interpreted that the Fourth Amendment is used for investigations of some sort.
Well, let me suggest you a different answer. There's a Supreme Court decision from 1961 called Mapp versus Ohio. Mapp versus Ohio is, this is Justice Harlan's concurrence, says we have to look at subjective and objective expectations of privacy. It also talks about the fact that the First Amendment protects people, not things. Now, the Fourth Amendment. Fourth Amendment applies, by the way, investigation, post-arrest, doesn't matter. It applies whenever state action is being done. Sorry? Katz says that? Yes, Katz says that, and Mapp talks about the other one. So we have these Supreme Court decisions, and the Supreme Court looks at wearing this bracelet or device and says, yeah, you know what, that's a search. It's a search because he has something affixed to him that he's being followed and tracked all the time. That's a search within the Fourth Amendment. And then the Supreme Court says, but you know, the Fourth Amendment only protects unreasonable searches and seizures. So they remand to North Carolina, which is the state that imposed the sentence on this individual, to decide whether or not requiring someone to wear this bracelet or this device is something that required a warrant. Although I can't imagine how it would. It's a condition of probation or post-trial release. I don't think it would go anywhere, but it was a chance for the Supreme Court to articulate one more thing, probably concentrating on the idea of we're protecting people, not things.
Isn't it an alternative to incarceration or house arrest that's maybe less restrictive?
Well, when you are subject to arrest and you're in custody, you have very restricted constitutional rights, at least in the Fourth Amendment area. And I would probably tell you, yeah, whether you're on pretrial release or you are subject to supervised release in the federal system, it's not called probation anymore, reasonable conditions can be imposed. The question is, was this condition a reasonable one? And we're putting into a constitutional term as opposed to just a term that I would put in for other things. Yeah. Yes, sir.
Is it relevant at all, the distinction between the person wearing the tracker and the police accessing the tracker's data? Like, by having the person wear the tracker, it's enabling the police to then access it either through a process with a warrant or without a warrant. Isn't that really the question?
Well, the question is, how is the police going to get the information that the individual has or the individual's conveying, right? How does the police get the information that the individual has on him or that the individual has conveyed to someone else?
So then it's technology independent.
Well, we're not at technology yet.
Right.
We're at really basic stuff. But the answer to that is there may or may not be a warrant required to get information from an internet service provider or some equivalent like that. And we haven't really gotten to that at the Supreme Court level yet. Courts of Appeals have addressed it. We had a Court of Appeals within the last few weeks address real-time tracking. And there has not been much real-time tracking case law anywhere at the state or federal level. But yeah, you can keep that one. We'll come back to that one in a little while. The other decision is City of Los Angeles versus Patel. This is a little different. This is whether or not you can well, I'm sorry. Let me do this and then we'll come back to that. City of Los Angeles versus Patel. City of Los Angeles passed an ordinance that says they can go in and inspect ledgers in hotels or motels, basically seeing who's there. And the question was whether or not there was a right of pre-enforcement review, which means can a hotel challenge what's being done before someone goes in and does it? And the Supreme Court says, no, you're a commercial entity, diminished expectations of privacy and the like. You're not closely regulated. And then at the end of the day, they say, oh, by the way, yeah, you have a right to pre-enforcement review. They send it back down. And this is the area of an industry. And this kind of goes to your comment before. There are closely regulated industries that have diminished protections. The more regulation there is of a particular industry, the less rights you have, reasonable expectations of privacy. Supreme Court said, no, you're not closely regulated. Hotel industry, you can go back and challenge coming in to do things on something called a pre-enforcement review. So let me go back to these other questions we're talking about that. And these are some things that came up after Grady. I asked before about Grady. Grady relied on Jones when they decided that there was search. Will Grady be limited to physical intrusions? We don't know. There hasn't been much case law that's been citing Grady, probably because it is limited to physical intrusions. We still have a lot of case law that focuses on Jones and the like. And the last is, will this unanimity we've seen continue? And I doubt it. I think there's a faction of the court that really would like to see Congress get involved in this rather than have the Supreme Court deal things on a piecemeal basis. We have at least one originalist now who may be seeing the world differently than everyone else does, maybe two originalists when the nominee is confirmed, which is going to apparently happen soon. So we'll have to wait and see for the next decision that comes up to the Supreme Court. Although I'll tell you, I know of none going up to the Supreme Court now in the area of electronic information, at least in the criminal context. There may be some statutes going up. There is a statute intended to protect children from violent video games that the Supreme Court dealt with a while ago. I don't see anything, though, in the criminal area coming up. So that's what the Supreme Court has done on everything for now. And then I want to spend a little time talking about reasonable expectations of privacy. And this is sharing information. This is what we talked about before. This is the third-party doctrine. Two recent decisions. If you share an IP address with a third party, you have no reasonable expectation in your IP address. Someone knows your IP address, your provider knows it. There's no expectation of privacy objectively when that information is given to someone else. Well, frankly, they give the information to you when you go into some type of a system. The other one is the aisle. That's an interesting case. That's on credit card strips. You know, your credit cards convey a lot of information on the strips when you run them through anything. Anybody know what kind of information is on those strips, or can be? Name, address, credit history, usage of the card, different locations. There's a lot of stuff that goes on those credit strips. And this decision, like all the other ones, said, look, you convey the information to a third party. It may not be apparent, but it's there. And when you give it to the third party, you have no objective expectation of privacy. Now, if you stop and think about Justice Sotomayor says, you know, maybe we need to revisit this area. We need to revisit it because the amount of information we're conveying now is astronomical. You really can't say you know what you're conveying, as opposed to the pen register device that was in Smith versus Maryland, which is obsolete now anyway.
Is this related to the issue of Rule 21, so you could show them your ID, but a lot of places are like, we want to scan it.
I've never been in one of those liquor stores, so I don't know. I haven't seen that. Well, I would tell you with that, to be honest, the first thing I would ask about is whether or not that's something that they should be scanning under federal or state law. There's the...
They say, you know, store policy.
They can have any store policy they want, but if it's illegal, you're not supposed to do it. The question is, who do you rat them out to? And do something with that. Yeah. Well, some of the new cards, the new Jersey license plates are supposed to be capable of being scrambled. Now, whether that's part of the Sign Act, which is going to affect this year or next year, and 46 states, I think, have agreed to that. So there's still four or five states that don't have all the biometric information, or whatever you want to call it, that's going on a license plate now. Stay tuned, but that's probably not going to be criminal. That's going to be invasion of privacy. I don't know. I'm not sure where that would fit in anything. I'd have to think about a cause of action for that, or walk out and don't get the liquor, go to the next store. It's probably the simple solution to that. Now, this is cell site location information. This is what I talked about before. This is Jones. And in addition to Jones, this is not Riley. This is Jones. This is sub diaz Osorio I mentioned before. And this is when the government wants to track your information. Give me 1 second, I'll get your question. When the government wants to track your information. And with an exception I'm going to talk about in a minute, every circuit that's addressed this says there's no reasonable expectation of privacy in your location. There's a statute known as the Stored Communications Act that allows law enforcement to serve an order on a cell service provider or the like. Information is given in response to the order, and that's how you can historically track someone. That's distinct from real time. Real time was sub diaz Osorio when they needed to track the car immediately, and you'll see that now when you see Megan's alerts on highways or whatever. I'll guarantee you that law enforcement is trying to find out what devices are in that car to try to find somebody. And probably there's no warrant requirement for that, realistically speaking. But Graham is from the Fourth Circuit. Fourth Circuit's out of Richmond, Virginia. It's considered to be a conservative circuit. There was a panel decision that came out, and a panel with 3 appellate judges said, yes, there is a reasonable expectation in cell site location information. En banc means that the case went back to the entire court. The entire court looked at it and basically said, panel, you're wrong, there is no reasonable expectation of privacy. Until the en banc court in Graham did what it did, there was a circuit split between the Fourth Circuit and other circuits as to whether there were reasonable expectations of privacy in cell site location information. The Supreme Court is more likely than not to try to resolve circuit splits. So this was a shot for another Fourth Amendment case to come up to the Supreme Court. The circuit split is gone now because what happened en banc. Yes, sir.
So in regards to the credit card strips thing, so they're saying that because you shared that information by swiping your credit card, you forfeit your privacy to all that information?
No, you didn't forfeit your privacy. You had no expectation of privacy. Okay, but that's what they're saying, yes.
They're now adding RFID chips to people's credit cards, which just broadcast that information. There's some regard, right? There's some security to that. But they're broadcasting all the time. Does that mean you have no expectation of privacy to anybody around you at all times for that information?
Well, let me ask you a question. You ever sit in a Starbucks and have coffee?
Not frequently, but sure.
Anybody ever sit in a Starbucks and have coffee? Anybody ever go on their computers around their Starbucks? Of course, why not?
Because I don't trust their Wi-Fi.
Because you're on a Wi-Fi. Wi-Fi is a shared network to some degree, right?
Now that said, I still go to the cell provider because I have to go somewhere.
Right.
But I sort of put all my eggs in one basket and trust that as one place where the information is.
If you have a cell service provider and you're giving a lot of information to a cell service provider, I would tell you under the third-party doctrine, depending on the conditions under which you gave that information to the cell provider, you have no reasonable expectation of privacy in it as a matter of law. And we've seen a number of decisions come out lately, and this is a new exploding area in criminal law of social media. Are there reasonable expectations of privacy in social media content? And one thing we need to do when we look at that, a court has to say, well, look, I got to look at the term and conditions. Or do I have rights? For example, do the service providers have rights to monitor what goes on social media? If we're talking about private accounts, if it's public, there are obviously no expectations of privacy in it. If you have 1,200 friends, you don't have an expectation of privacy in anything either. I mean, let's be realistic about this. So my answer to you, generally speaking, and subject to me having to look at more stuff, would be no. You communicate the information voluntarily to a third party. No one tells you you need to use a credit card. You can walk around with cash all day, and you can have checks and do everything on that. That's voluntary. No federal court has gone really on this concept of expectations of privacy and given some kind of heightened protection because of the information that's being transmitted.
So, sort of along the same lines, if you have some Bluetooth device and you're transferring data from one device to another across Bluetooth, that is a broadcast. Does that mean there's no reasonable expectation of privacy for that data either?
There may be a wiretap act question depending on who intercepts it. If you're communicating the information back and forth devices, it's your device and another device, it's going to a cloud provider? Yeah, probably. So the question is, do you have any expectations of privacy when you're communicating from one device to another? The immediate comment, again, I would make is look at the terms and conditions and see if they can monitor what you do. If they can monitor what you do, then you probably don't have an expectation of privacy in it. And that, by the way, I mentioned the Stengart decision from New Jersey. The employer argued we can access her email in her Hotmail account, whatever it was she communicated to her lawyer, because we have a right to monitor what she says when she goes through our network. Now, the Supreme Court found that ambiguous. I didn't see an ambiguity to it, but the New Jersey Supreme Court is very protective of privacy rights and constitutional rights. So I think we can have a discussion about that, but there are other decisions around the country that look in these terms and conditions and say, look, they can monitor it. Not only can they say they monitor it, but they actually do monitor. So it's not like having something you could do that you can't do anymore. So the state and the law on the federal side, basically, if you're communicating it to a third person, there's no expectation of privacy. But even if there is an expectation of privacy, the Fourth Amendment only protects about unreasonable searches and seizures. So it may be sufficient to get an order under the Stored Communications Act where law enforcement basically has to certify they have good cause for something, as opposed to requiring a search warrant under the Fourth Amendment. And the difference between those two is there's a probable cause requirement, as opposed to just good cause.
So a case for people if they're interested is the U.S. v. Warshak is a went en banc
Sixth Circuit
decision on email, and found that there was a reasonable expectation of privacy in your email, but as you're suggesting, it's contingent on looking at the terms of service, and if it's exceptional or if it's in the ordinary course of business that the email provider is going to actually look at the contents of your email, shapes whether or not you've got an expectation of privacy. So for something like Gmail, which routinely, but in an automated way, right, looks at some of the contents of your email, right, raises an interesting question. I don't think there's been any cases with Gmail that have popped up, but.
No, but we're going to talk a little bit later on about some new things that are going on that are kind of outside what the Supreme Court's doing and talked about. But they're fascinating. It's probably something that would interest all of you because you are the Center for Information Technology. So these decisions are focused on technology. And we're going to be seeing a lot more of that, obviously, because we're seeing more and more technologies. As I said, we don't have time to talk about encryption, double key encryption or the like. That's going to be a big area on the criminal side, obviously, although in Fifth Amendment, as I mentioned before, probably Fourth Amendment. And it's also going to start figuring in civil litigation because there are going to be arguments being made. I forgot my password or something like that, and what does a judge do to compel you to remember your password? And then the answer to that is, yeah, there was a decision in Massachusetts where someone was imprisoned for contempt because he didn't turn the password over, and a few days after in prison he remembered his password. So sitting in jail for a day or two sometimes convinces people to do things. Anyway, so that's where we are on reasonable expectations of privacy. And I want to talk about states because you need to remember we're in a federal system, and we have state courts that don't necessarily do the same things on the state side that the feds do. First is Earls. Earls is an old one. This is a cell site tracking case from New Jersey, pretty old one. It imposes a warrant requirement, which means you can't get information on tracking unless you have a search warrant signed and based on probable cause. And the reason they went that way as opposed to the way the feds did on this location information is because the New Jersey Constitution gives greater rights than the Fourth Amendment does. New Jersey Supreme Court has always said that. We can look at the Fourth Amendment as a floor, if you will, but our Constitution gives more protections. There are a couple decisions from states that have gone this way. There aren't many states that say their constitutional protections are broader than the Fourth Amendment. So you're going to see in a lot of times when Supreme Courts have not addressed these issues yet from the states, they'll be looking for guidance from the U.S. Supreme Court or from circuits in some areas. The second is out of Maryland. This is relatively new. Cell site simulator. Everybody know what a cell site simulator is? A stingray and the like, broadcasts a signal that makes some cell phone think it's got a cell site next to it, and it gets pinged essentially. And it's interesting. Now, Andrews is based not on state constitution. It looks at the Fourth Amendment. And it's really going on this idea that the third-party doctrine really doesn't apply here because on top of everything else, you don't know what you're doing. It's being done automatically. Whether this survived in a federal court, I don't know. The only thing that can happen to this now, it goes to the Maryland Court of Appeals, which is the highest court. I haven't heard that it's gone there. And the only kind of review available after that would be direct review to the Supreme Court. Unless at some point there was a habeas petition filed. Well, this guy is winning so far, so unless his conviction is reinstated by Maryland and the Supreme Court turns it down, his only relief would be some type of habeas relief, probably getting him nowhere because of the Anti-Terrorism Act that put limitations on habeas relief in the federal system. And the last one is Tracy. This is cell site information again, but just to show you how states go, Tracy looks at federal law, the U.S. Constitution, and says there's a warrant requirement, which the circuits have uniformly rejected now. But it's interesting to see what the courts around the country are doing. We're starting to see courts of last resort and jurisdictions addressing all these issues. Cell site location information, tracking information, and the like. And I would predict to you, as I mentioned before, the next big area of explosion we're going to have is encryption and social media, although there's nothing exciting about social media. The most interesting thing for social media is admissibility, and that's getting it proven that it is created by who it is supposedly created by. Because you can spoof a lot of you can spoof a lot of websites and social media accounts.
So slightly off the topic, the question. It turns out there are plenty of people who have Facebook pages that they have nothing to do with because they are public figures. So how do I prove in particular that I don't have a Facebook page even though there is one?
Well, if you had to do, well, first off, you don't have to prove anything. If someone's offering it against you, they have to authenticate it. So if you're a criminal defendant, the best thing to do, I've never heard a criminal defendant who opened his mouth and did anything to help him. That's why we have the Fifth Amendment. I suppose the state will have to get up, or the federal U.S. attorney will have to get up and say, they're an issue of ownership. And by the way, there's a new decision that came out of the Third Circuit a few months ago called United States versus Brown, where this exact question came up where the state, actually it was the state, it was the Virgin Islands, was prosecuting someone and wanted to get into evidence a website. And they said, well, there are enough indicia on the website. I identified you. There was a terms you would use. The dates are consistent. There are a lot of ways to authenticate something. So the answer would be, yeah, they would have to say, where did it come from? The easiest way to do that on the civil side, frankly, is to serve a request to admit on the other side. They request it, or depending on the severity of what you're admitting to, you can sign a stipulation saying, this is my Facebook page, but by the way, all that means is the Facebook page or the social media content, social media itself is admissible. It doesn't say anything about content. So you can still challenge content even though the actual page is, the actual document or the page, what's called a document, is being admitted. Interesting, there are a couple amendments to the Federal Rules of Evidence that are up for approval in December that's going to talk about self-authenticating social media or different types of electronic communications. So you don't have to bring someone in to say, yeah, I work for Apple and I do this and I do that. And yes, this was generated and the like. So that's the area that we're seeing a lot of development. Other things going on, there's something new every day. And we're going to chat about all that in a minute or two because I'm running out of time. Okay, how many people know about Microsoft? Microsoft case. Anybody hear about that? The servers, the U.S. attorney wants information. The information is located on a server in Ireland. And the Second Circuit went up to the Second Circuit and said, you know what? The information is in Ireland. Under federal law, there is a presumption against extraterritoriality, which means we don't assume that statutes apply outside the United States unless Congress specifically has said that. That's all this case says, that the servers were located in Ireland. They're outside the United States. United States government can't reach them because the controlling statutes or rules aren't intended to reach stuff outside the United States. The Second Circuit en banc, you see, denied a hearing a month or so ago. Apparently this is going up to the Supreme Court. I believe there's a petition for cert being filed. But don't get carried away by any of this. This is not a privacy decision. This means nothing other than a statute doesn't reach a certain thing. So I know a lot of people talk about being privacy related. All Congress has to do is change the law, and this disappears. But this is one of the latest things going on. But we have another one now that just came out. This came out early this month. This is out of Pennsylvania. There are warrants issued for information on Google accounts. There are 2 targets in the United States, and the criminal activity is taking place in the United States. Google refuses to give it because it says they'll give what they can give you on servers here, but they won't give you stuff on servers overseas or in different locations. The problem is Google doesn't know what's where because Google divides all their information into packets. And a packet can be in the Netherlands one day and something that's shipped between servers everywhere. And if you're looking at me incredulously, all I know is that's what Google told the court. So if it's not right, it's not right.
Seems incomplete.
They don't have the capacity to get the information. So the court said, well, you've got all the information. It can be brought here. Get it here. That's where we are in this decision. Now, I mentioned a technology decision. This is a technology decision. And it's really based on what Google says it can and can't do. And I think the response is a very good one. The response is, look, you're responsible for your technology. We want information produced in the United States. It's circulating every place. You don't know where it is. Bring it to roost in the United States and turn it over to the government under the Stored Communications Act. Well,
Why would that same logic not have applied to Microsoft?
because Microsoft knew the information was in Ireland. They stored it on a server in Ireland. Google says, we don't know where it is. We break everything into packets. We don't know where everything is.
I think the court could have ordered Google to figure out where it is.
The court doesn't care. The court just said, you don't have the technology, bring it. Why would a court want to do that?
Google says they can't tell where it is.
That's what they
I see,
say.
and that's-
Big table spread across.
It's
multiple
also-
servers.
It goes in multiple servers in different locations, and they say their technology can't tell you exactly where it is. Now, interesting how this is going to go forward when you have information in different places, and you're sharing information, and you, the company, don't know where everything is. Now, this has not gone for review in front of a district judge. I expect it will. Google, I expect, will try to pursue this. If the district court, or whatever the district court does, whether it affirms or rejects this, it's probably going to go to the Third Circuit. But then, of course, what could have happened is Google just said, look, I'm not going to fight this. Here's the information. I'll wait for another day. But I don't know what's going on with this. This just happened, as I said, 2 weeks ago or so. Yes, sir.
The flip side of that, how about the European courts demanding access to information in the United States?
What's wrong with that?
I'm
You
not
do
saying there's
business-
anything wrong with it.
By the way, the Europeans don't have a constitution that protects them. So if you look at some of the statutes being passed in the UK and France now, they can get anything they want from a company doing business in France. And there are no rights that anybody really has, and some of them don't need warrants. You can just get information on demand from an investigator. So my answer to you is there are a lot of countries that have a lot of different regimes than we do. The Fourth Amendment applies here. And it applies to people here and not to things in different places. Could I sign an order requiring you to repatriate information on the civil side? Yes. If I were a judge, I could. I've done that before. The alternative to that is to allow letters rogatory to be issued to you. Let's say you're a European country a European company, you're doing business in the U.S., you get sued. And you go to me as a judge and say, Judge, I can't give it to you because French law bars me from giving it to you. There's the European Privacy Directive about to be superseded by the new European privacy rule. And by the way, France has or had a blocking statute, which says we can't give you certain trade secret information, whatever. I did that once. Letters rogatory. It took me 11 months to hear that I couldn't get the information. So the next day I signed an order requiring the party to turn it over. The Supreme Court has said you can do that on the civil side. If you risk penalties in another country, that's too bad. That's the price of doing business in the United States. But yeah, that's kind of where we are. The law's not that well settled in this area, at least with technologies, when you've got information located outside the United States. One of the things that was talked about here as an alternative to requiring information to be turned over is a multilateral assistance treaty. And basically what that says is we in certain countries enter into treaties among ourselves that allow certain information to go back and forth. The problem is it's not with every country. Some of them take a lot of time and the like. So that's kind of where that went. The only other thing to talk about, and we've got like 10 minutes or so, is another Microsoft case. Has anybody heard about the Microsoft litigation against the United States and Washington State? Probably hasn't hit much. There are things that the government can issue to internet service providers requiring them to produce information in response to requests. These things that the government issues also have provisions in them that say you, provider, cannot disclose cooperating with us. That's been struck down as a First Amendment violation, at least to the extent that the warrants or the orders did not have any end date. And the argument basically is you have to have an end date to these things. You can't keep this open forever, especially when investigations are over. Interestingly, the judge who just decided that in Washington is the judge who just entered the TRO on the exclusion order, if you want to call it, the immigration rule that Trump just had struck down. It's apparently being reissued in some other goofy form today. Well, in any event, that's kind of where we are. So that's Fourth Amendment issues. Talked a little bit about the third-party doctrine, a little about what states are doing or not doing, and I hit a couple new things that you folks might be interested in. And that's it. So any questions or any comments or the like? Got 10 minutes. Yes, sir.